a couple of examples, hypotheticals. So this one, the first one, Acme has a prime contract to provide flight control systems, FCS, for helicopter ambulances. So senior staff meeting happens. Acme's attorney, Allison, hears quality concerns about the FCS. The main components she learns have come from Never Never Land, not from USA. This does not qualify as domestic for purposes of the Buy American Act, and Allison suspects that Acme's FCS proposal was non-domestic and should have made it non-competitive for the award. After the meeting, Allison goes down to contracting and looks at the proposal, and sure enough, it has been certified as being domestic, even though Allison now knows that one of the components is coming from somewhere else. Allison goes to see the CEO. She expresses her concern, but before she even gets to the Buy American Act, he says, look, maybe under U.S. law they'd have a product recall, but under the law of Never Never Land, the parts are fine, we don't have a problem, leave me alone. She explains what the problem is, and she says, and the CEO says, don't worry about it. I'm not questioning it. I'm not an accountant. I'm not the lawyer. Don't worry about it. So now she goes to head of contracting. She asks him about the Buy American Act, and he says, we got it through a U.S. supplier, and the CEO told me it was enough to make it domestic. I do what I'm told. So just some notes for this. Typically, government contracting attorneys aren't going to look behind and see if, is it domestic or not. They're going to take what the contracting officer says is true. And you should know that an intentional false certification of saying something is domestic is a violation of the law. It's a potential criminal violation. So some questions we can go through. And let's go to the slide with the answers. So question 1, the communications at the staff meeting where Allison finds out that the products are coming from somewhere else. Are they privileged and are they confidential? They're definitely confidential. So she learns about this through her client that she's representing. It's confidential. Probably not privileged because the communication wasn't made for the purpose of obtaining legal advice, so it's probably not privileged. This means that you're in the land of 1.6 and 1.13. Would the general concern about the quality of the products be enough to have Allison disclose this confidence? Probably not. It's just a general concern. She probably doesn't have enough information to really have a real reasonable belief that this is going to cause a concern to safety that might result in death or injury. Now, if she did have that information, it would be different. Conversation with the CEO. It's probably going to be privileged, even though the CEO is acting stupidly. We have clients who say stupid things to us all the time, and that's why the attorney-client privilege is there, because we can't reveal that. How about the contracting officer? Now, definitely subject to duty of confidentiality. As to whether it's subject to the attorney-client privilege, it's going to be a closer call. It depends on what the contracting officer's level is. I think on the slide here it says duty of confidentiality only. I think you'd have to look into that much closer because it might not be under applicable state law. It might not be subject to the attorney-client privilege. So if there was false claims litigation, are the records in Acme's contracting department concerning the origin and pricing of the component shielded from discovery as work product? No, right? Because work product only applies if the document was created in anticipation of litigation and it wasn't. So now the question where we came back before is Acme is required to disclose under FAR 5203-13. If it refuses, may Allison, under Model Rule 1.13c, disclose because of the violation? If Acme fails to disclose, it is committing a violation of a legal obligation to the organization. So Allison must report up. Okay, so she has to report up. That's what she did when she went to the CEO. But 1.13, she may report out because it's clearly a violation of the law. So here she would be covered by being able to go to the inspector general, to someone else, and say, listen, we have a problem here. They may be committing a crime.